avoidance of any doubt.
Good morning, everyone.
Good morning, Mr. Brown. And the court, for its part, also does not believe there's a conflict either in Michigan court rule or the cases decided therein. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Charles Williams. Yes, sir. Your name, sir?
Charles Williams.
Is there a prosecutor here?
Wasn't she?
She went.
Oh, here she is.
Oh, no. No. Take your time.
I'm so sorry. If you're with different people.
All right. He's waving.
Yes, Your Honor. You have to sign.
I do. Mr. Williams, you're waiving your right to a preliminary examination?
Yes.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Brown.
I'm not agreeing on behalf of Charles Williams and request retrial from Judge Simpson.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
April 9th at 1:30 for Judge Conlon.
April 9th, 2025, 1:30, Judge Conlon.
Yes, bond.
Bond continue.
Thank you.
Are you ready on this one? Hey, what are they doing?
Yeah.
Court does call the case People versus Mike Jones.
Hey, we're to different people. Just one.
Denowitz.
The attorney. Yeah. I believe it's a waiver. So.
Just a moment, sir.
It's not just me.
I know that doesn't make it any better. Go ahead.
Good morning, Your Honor. Assistant Public Defender Ben Dunaway. On behalf of Micah Jones, who stands to my right. Mr. Jones, would you state your name for the record?
Thank you. He's waving.
He is waiving, Your Honor. He is signing the form right now.
Sir, you're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on the single count. Counsel, your turn.
One date, Your Honor?
You waive reading of the information?
Oh, yes, sorry. Stand mute. Formal.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
April 7th at 1:30 before Judge Conlon.
April 7th, 2025, 1:30, Judge Hamoud.
Thank you, Your Honor.
Thank you. Bond continue.
I'll come back.
You'll come back?
I will.
Why are you threatening me? It's that.
for now.
The whole,
Oh, yes.
so,
We know for sure we have one. Otherwise, we're waiting potentially paperwork. Let us know what the.
so why don't they know? You.
All right, 14A District Court back in session with the Honorable Judge Simpson for five.
You may be seated. Mr. Brown, how are you? Are you? I'm doing great. um,
Happy early birthday.
I'm sorry.
Happy early birthday.
Oh,
Your birthday coming up.
you are like a stalker. What? What? Yes, we are both Aries. Oh, okay. Well, thank you.
My birthday's coming up then.
That's true. I did know that. You're surrounded by a bunch of Aries. What do you say, Simon? So what Brown say? Either one of them.
We're talking about Natalie.
No, that's not what you said. You said something else.
Maryland.
One of the Maryland colors, yes. Thursday, I will be decked out in all red. They're there. Sure. Court does call the case of the People versus Calvin Fuqua.
Thank you so much for appearing on behalf of the people who are Brown Creek on behalf of the school.
Your name, sir? Thank you. Is he waving?
No, Smith.
Okay.
This is the date and time set for the examination. The officer involved is a former elected officer. Start off, it said notice there, or today's date, he has failed to appear to people on. Move to dismiss.
People being unable to proceed, this case is dismissed. That's on defendant's motion without prejudice. Thank you. Court calls case People versus Zenyi Yu.
Ready.
And then we have the people.
Joe's on behalf of the defendant. Will state your name. No love.
Oh,
Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, people are unable to proceed as to count one, and we ask the court to remand on counts 2 and 3.
No objection to this dismissal.
Count 1 is dismissed. The case is remanded to the 15th District Court on counts 2 and 3. I'll set a pretrial date.
April 16th at 9 a.m. before Judge Perry.
April 16, 2025. It's at 9 a.m. 9 a.m. before Judge Perry.
You've already given my client permission to go to California.
I did?
She returned for today's date. She wants to return to California. She'll make her court dates. Judge Perry usually allows that first injury. So we're asking permission to return.
No objection from people. Your
All
Honor.
right. So she normally resides in California, is that?
After this today, Your Honor, she re-engaged with her mental health treatment, which is based in California.
Okay.
And that is her permanent.
So what I will do is her bond will continue. Defendant may travel. And she resides in California, correct?
Yes.
Right.
Yes.
Okay. So I'm going to word it this way, that she may travel and reside in California, but must return for court dates or court proceedings. Of course, if Judge Perry allows something else.
Thank you.
All right, thank you. Court calls the case People versus Tamia Harris. He was lurking around all morning. Next door. Bernstein, you know where he is? Okay, gotcha. Appreciate it.
Dan Burns, on behalf of Ms. Harris.
Your name? All right. I have before me a plea form, and I'm assuming this was supposed to be an attempted. And it. Okay. Huh? You mess this all up. Hold on. I don't know if my pack codes are. They're not. They're not. You did. Jeez, oh Pete.
I promise.
No, don't worry about it. I'll fix it. All right. So I think how this is supposed to read, and now kind of does, that she's going to be pleading guilty to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, sir.
May I have your sworn?
Raise your right hand. Solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth. State your name for the record.
Tamia Harris.
Do you have gum? It's right there. Okay. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. Is that correct? That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that? All right. You understand also that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights from today, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there for.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you're guilty of this offense? February 8, 2025, at the location of 1490 DeSoto in Ypsilanti Township, Washtenaw County, State of Michigan, did you come into contact with police officers?
Yes.
What happened that makes you think that you're guilty of this offense?
I was interfering, obviously, with their system.
So somebody was being arrested. You knew they were being arrested, and you interfered with that arrest. How did you do that? Okay. And you knew it was a police officer doing that.
Yes.
Correct. All right, counsel, have I complied with the court rule?
Yes, sir.
Court will accept the defendant's plea to count 2. Plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
At 10 a.m. before Judge Washington.
May 15, 2025, 10 a.m. before Judge Washington. So when you grab the arm, how'd that work out? Not well? Yeah, okay. Just checking. Bond will continue. All right, thank you. Yeah, it didn't work out well because you're here, didn't it? Son? Figured that out on my own. Court calls the case, People versus Anita Payne.
Andrew Childers appearing on behalf of people.
We're ready.
Brown.
Hello, my name is Anita Payne.
All right. I have before me a plea form that indicates defendant will be pleading guilty to attempted custodial interference or kidnapping custodial interference, the 6-month offense. Upon her successful plea to that charge, the kidnapping charge, custodial interference, would be dismissed. There is further the agreement, although, well, I guess it's me. It's okay to seek a deferral pursuant to statute.
That's all right.
That's the court's full understanding of the agreement. Is that correct, Mr. Brown?
That is correct, John.
Thank you.
May I have her sworn?
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
My name is Anita Payne.
All right. Did you need to finish? Go ahead. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted kidnapping custodial interference. Is that correct? That is a misdemeanor punishable by up to 6 months incarceration and a $2,000 fine plus court costs. Is that?
Yes.
All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights. You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Yes, sir. Oh, no.
All right, let's try that again. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge? Has anybody threatened you or coerced you? You're doing this voluntarily
Yes.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty?
Yes.
December 2nd, 2024, at the location of 4511 Packard Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custodial possession of a child at that time? Physical possession.
Yes.
All right. And at the time that you had that physical possession of the child, was that child supposed to be returned to the other parent
Yes.
at that time? And had a 24-hour period passed?
Yes.
Since, I guess I should clarify that. The child was supposed to be returned at least 24 hours prior to the time that you did.
Yes.
All right. And you just failed to do so.
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor, the people are set.
Vince is,
The court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
April 30th, 12, yeah.
Could this be on the TV docket?
Sure, it could. I can put it wherever I want. No, what? You're saying that's where you believe it belongs.
April 1st at 1 p.m.
Sentencing will be April 21st, 2025, 1 p.m. And that's before me. Yes. I saw you sign the sentencing judge waiver and I didn't know why. Was he trying to like not have me? What was he trying to do? He was up to something. What? Oh, okay. Yeah. All right. It'd be before me on that date. On your way out, you may want to stop by my probation department to get that started, that process. All right? What?
What's the date for?
April 21st.
Well, I was going to set another date, but then Childers jumped in. So I set another date, and you weren't listening. The only person that was listening was your client. Are you good now, Malone? Are you good? I know you're good. Are you good? Okay, bond continued. What? No, it's at 1. I don't know why I bother talking. Just I don't. You got it? Finally? Ma'am, what date did he write down?
The 21st at 1 p.m.
Okay, good enough. All right. Thank you. Just double checking. Court calls the case of the people versus Robert Jones.
Males then that we have.
Assistant Public Defender, we have Mr. Jones. Who is approaching the podium now. Mr. Jones, state your name for the record, please. Robert Jones.
All right.
And Your Honor, it is going to be no contest.
I have a form that indicates that the defendant will be pleading no contest to the charge of aggravated domestic violence, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is the agreement between counsel of no upfront jail. I don't do that, but I see that that's the agreement, understanding of counsel.
That's right.
All right. Is that a correct statement?
That's right.
All right, let's have him sworn.
Raise your right hand. You solemnly swear or affirm to tell the truth and the whole truth, nothing but the truth, so help you God. Yes. Robert Jones.
All right. So it is this court's understanding that you are going to be pleading no contest to the charge of aggravated domestic violence. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that? Do you understand what a no contest plea is? Let me explain 2 things about it just to make sure. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Now, understanding all, and the basis for the no contest plea is potential civil liability counsel.
I can remember this is about 5 years old.
Sir, to the charge of aggravated domestic violence, how do you plead?
No.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole? You are? Were you on probation or parole at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2416061. Any objection to the court having reviewed that report?
Not for the people, Your
None
Honor.
from defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
You are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be, it's a DB.
April 21st at 1 p.m.
April 21st, 2025, 1 p.m. That is before me. Bond will continue.
Thank you.
Thank you. Sir, you may want to stop down at the probation department down the hallway and just check in and get it started. Okay, thank you. Court does call the case of People versus Cody Tournier.
As and on behalf of the people. Court Doctor Charlotte Stephen on behalf of Mr. Tournier.
All right. And what are we doing?
Your Honor, today's date comes up with preliminary examination. At this time, the people are unable to proceed as to count 1 and would move the court to add count 3 of telecommunications, now used domestic relationship, and remand on count 2 and the added count 3.
Okay, so you want me to add a count?
Yes.
Okay. Count 3 is what?
It's the telecommunications now used domestic relationship, and then I have the pack of the court.
Yes. I'll use. Yes, PAC code.
750.540E1H. And it's a 6-month, $1,000 fine.
E1H.
Yes.
Okay. That is actually count 3. And count 3, you waive presentation of the complaint on that charge.
Yes, we do. We have no objection to the dismissal.
All right. And your client enters a not guilty plea to count 3.
Yes, Your Honor.
All right, very good. I'll enter that not guilty plea to that charge. There being no further further reading of that. Count 1 is dismissed. Set this for pretrial.
April 10th at 2 p.m. before Judge Fresh Hour.
April 10th, 2025. What time?
2 p.m.
April 10th, 2 p.m. And that's before Judge Fresh Hour.
Your Honor, I'm not available at that time. I have a preliminary examination in Oakland County at 2 o'clock. Is there another day?
Let me see if we have one. You may have to deal with Judge Fresh Hour staff. We don't have another pretrial.
I'm just checking it.
I'm thinking it's going to be a DV. That was a DV day you did, correct? Okay. Let's see if we got one.
The next one would be the 24th at 10 a.m.
Oh, that work for you?
It does not.
Okay. Why don't I do this? Why don't I give you, so there's at least some additional time, the 24th at what time? 10?
10 a.m.
At 10 a.m. before Judge Fresh Hour. I'll let you then, that'll give you time to contact them.
I appreciate that, Your Honor. Thank you.
All right. Bond will continue. Thank you. This is the last one?
Yep.
Whose case is this?
It's possible.
I'm out.
You can just be done with it if you want.
That's it. I finished up. I'm leaving. What are we doing on this? Why is she? Hold it. Is that rushing? Why is she here? Why is she here and sitting over there like a little chameleon trying to blend in with the background? Who, Russian? Oh yeah. No, Russian. I can't call her a chameleon. Okay. I'm sorry. Court has called the cases of the People versus Elroy Love. All three cases.
Your Honor. Christina Constantino appearing on behalf of Mr. Love. Mr. Love, can you please state your name for the record?
Elroy Marlowe.
All right. What are we doing?
And Your Honor, today is the date time set for preliminary examination. At this time, all the case numbers, internet statute, I can't pull up the file numbers. Do you need assistance? Yes, you're gonna pull them up.
Your internet now?
They're sending somebody over.
So hold it. Why is his working?
My laptop is currently That's why.
Why'd they give her the cheap stuff?
My microphone doesn't.
Okay, so it's just a patchwork of stuff. Okay.
Oh, yeah. Okay, yes, this. I mean, these are my. Okay, Your Honor, as to case 23 FB 1460, the people are unable to proceed as to count 1, would ask that counts 2, 3, 4 be remanded to district court. And then, as to case number 23 FB 1442, the people are unable to proceed as to count 1 and would ask that count 2 be remanded to district court. And then the people are unable to proceed as to case 24 F2 1557.
Okay. Okay, so let's start with, in case the ending in 1557, people being unable to proceed, counsel, you're moving to dismiss.
Yes, Judge, we would be moving for dismissal.
People being unable to proceed in that case, this case is dismissed on defendant's motion without prejudice. So, then on the case ending in 1442, count 1 is dismissed. The defendant continues his not guilty plea as to count 2. I will set a pretrial in that matter to DV.
Yeah, April 21st.
April 21st, 2025, 10 a.m.
Yes.
10 a.m. before Judge Washington. And in that matter, his bond would continue. And then in the case ending in 1460, count 1 is dismissed. And he'll continue his not guilty pleas as to counts 2, 3, and 4. Pretrial in that matter will be set for
21st at 10 a.m.
April 21st, 2025, 10 a.m. before Judge Washington.
Judge, if I could address bond.
Of course you. Go ahead.
Yes. So given that there were several felonies that were dismissed, especially in regards to case number ending in 1442, Mr. Love now faces a 93-day misdemeanor. He has been incarcerated since, I believe, February 14th, Valentine's Day, which is very fitting considering his last name is Love. But he has been in custody now for about 40 days, 45 days now. So given that he's served about 45 days on a 93-day misdemeanor, we'd ask the court to consider a personal bond. And I'd ask the court to consider a personal bond on the other case as well. He is 31 years old. Should he be released, he would be residing in Milan, Michigan with his brother. His brother is present in the courtroom. His brother has been actually present at all of the last court hearings and is very supportive of him. He does have employment lines up at Best Games. He would be working full-time there as a manager. It's my understanding it was confirmed that job is still available for him. He has 2 children. He has a high school diploma. He's very much involved in nonprofit work, working with churches and helping do advertisements for the churches. He also has a connection to potentially secure alternative employment at Milan Metals as well. So we would ask the court to consider personal bonds on these matters. And we'd suggest any risk to the public or flight could be accomplished via a tether.
Response from the people.
No, I'll leave it to the discretion of the court. We would ask for the tether.
And you do understand, sir, that there is a no contact with Ms. Nobles?
Yes, Your Honor.
All right. Set his bond in each of these cases, $5,000 personal recognizance bond. I will also indicate that the defendant is to be placed on a GPS tether location tracking.
Thank you very much, Judge.
All right, thank you. He's getting Is that it? Miss Perrini, you didn't have anything? How come they won't let you do things?
I had things next door, but I'm not. I was wanting to say something, happened.
Well, you should have told me. You know, I can make things happen. I will now. 14A stands adjourned.